Welcome to the very well attended, so happy to have you all, presentation today from Mark Rhoads and Crystal Malik on the latest information in hiring international talent, visa tips for U.S. employers. My name is Marianne Thompson, the president and founder of GoinGlobal, so happy to have you as our guest for today. Let me tell you a little bit about the webinar, a little bit about Mark and Crystal, and invite you to submit as questions as you can in the chat feature of the presentation. Mark and Crystal have a lot of information to share, so probably will not be able to answer all of them, but you will be provided with Mark and Crystal's contact information should you want to contact them after the presentation. So it's with great honor that I tell you a little bit more about Mark and Crystal. They're probably recognized as some of the top immigration attorneys here in the United States. They're affiliated in Richmond with the law firm of McCandlish Holton. They work with companies and universities throughout the United States, and they have under their belt thousands of successful work visa and green card applications that they process each year. Mark and Crystal, again, frequently collaborate with university. They counsel staff and students on the latest guidelines for successfully navigating the U.S. immigration process. And then, of course, they provide the much needed support on the other side to the employers. We're so happy to have you better understand how to take advantage of the talent we have within our borders and to use them to your best use. Mark has been repeatedly recognized as one of the best lawyers in America for immigration law, while Crystal has been highlighted as one of the best lawyers in America, one to watch in the same field. There's so much to learn today. You'll really appreciate the counsel and advice. The H1B season opens right around the corner, March 6th to the 22nd. So in a minute, we'll turn to Mark and Crystal, but since we do have some newcomers to the call, let me tell you about GoinGlobal. We are the market leader in providing career and employment resources for 120 locations around the world. We have custom curated, copyrighted content, not only for countries, but on 47 cities in the U.S. So the international talent on the phone today, I know, is particularly interested in our U.S. city career guides. We have jobs and internships. We have H1B and OPT visa information. We have key employer information. So those of you on the phone who are not currently GoinGlobal customers, employers, if you want to know anything more about GoinGlobal, please contact me directly at president@goingglobal.com. So we can leave as much time as we can to hear about our resident experts, Mark and Crystal. Again, please put your questions into the chat box. We'll answer them as we can, and then as our gift to you, we'll provide you with Crystal and Mark's contact information and provide a recording to their presentation as well. So with no further ado, it's a great honor once again to introduce my fellow lawyer colleagues, Mark and Crystal. Mark, I think I'll turn it over to you.
All right, thanks very much. Crystal, pop it back to the previous slide for a second. So Crystal and I are both immigration attorneys, as Marianne said, and our office is actually based in Richmond, Virginia. And although we're based in Richmond, we represent companies all over the United States. One of the benefits of immigration law is that it is federal law, so we're not bound by state boundaries, and we represent companies coast to coast. And we process thousands of work visas and permanent resident green cards for international employees of U.S. employers every single year. And I can tell you that in working with companies, and I've been practicing immigration law for about 28 years and working with thousands and thousands of companies over the years, most employers in the US don't really have any idea how the immigration process works. So what we're going to try to do here in the next 40 minutes or so is to give you the roadmap that we both typically see that US employers use to hire international students when they graduate from a US college or university. And I emphasize that we're going to focus on the employment options after graduation. There are lots of different ways that international students can work during their degree program, like for internships or something like that. That's a topic for a different day. What we're going to talk about today are the pathways that international students use to stay and work in the United States, and that US employers use to hire international students on as employees. And we're going to be giving you a lot of information over the course of the next 40 minutes, probably more than you can absorb. So I encourage you to keep our contact information, which is up on the screen right now, because we will answer questions for free. We've been doing this for many, many years, and we field hundreds and hundreds of questions from US employers about the immigration process, and we're happy to answer those questions by phone or by email, and we don't charge for that. So it's a great free resource for you. I encourage you to hold on to our information. Next. So this is the, as I said, I've been practicing immigration law for about 28 years. I've worked with thousands and thousands of international students. And when you look at the different categories of visas that international students can use to stay in the United States, the most common visa for an international student is called F1. So every international student that is in the United States in F1 status, and that's the vast majority of them, when they graduate from a US college or university, they will get a work authorization card that is called an optional practical training work card. Optional practical training, what I call OPT, is the very first step that an international student will use to stay and work in the United States. In their last semester of their program, they apply for a little work card. It's called an employment authorization document. It is their optional practical training employment authorization document. The great thing about that that OPT employment authorization document, the work card, great thing about that for an employer is that the employer doesn't have to do anything. As an employer hiring an international student, you don't have to pay any fees to the government. You don't have to file any paperwork with the government. As long as the student has that optional practical training work card, they can go to work for you after graduation, doing any job anywhere in the United States, as long as the job is related to their degree program. So OPT is typically the first step that an international student will use to stay and work in the United States. Every international student in F1 status who graduates from a US college or university gets up to 12 months of OPT. Unlimited work authorization for any employer anywhere in the country as long as the job is related to their degree program. They get that for up to 12 months. If they are in a STEM degree program, science, technology, engineering, or math, they can apply for an additional 24 months of optional practical training for a total of 36 months of work authorization that doesn't require the employer to file paperwork. Well, they do have to, for the STEM extension, there's one small training plan you have to submit, but no fees to the government. It's a great way for employers to get a look at an international graduate of a US university with very little commitment. While the student is working using the optional practical training, whether it's for 12 months or the 36 months of OPT, you're going to want to start thinking about a longer term work visa to allow them to stay after their OPT expires. And the most typical long-term work visa in the United States is the H1B. And in a minute, Crystal is going to go through the ins and outs of the H1B process. But H1B will allow that international worker to stay and work in the United States for up to 6 years. And in some cases, they can work using H1B even beyond 6 years. So again, the typical path starts with optional practical training. while they're working using their optional practical training, you're going to want to think about pursuing the H1B work visa that will allow employment for up to an additional 6 years. While that international worker is working using their H1B, that is when most employers and most individuals start to think about the permanent resident green card. The permanent resident green card will allow that employee to stay and work in the United States for the rest of their life. They can work for any employer without restriction, travel freely in and out of the United States using that permanent resident green card. But the green card is also a discussion for another day, because for most employers, the vast majority of employers, you're not going to want to think about permanent resident green card right out of the gate. What you're going to want to do is get this individual working for you using their optional practical training, which again doesn't require you to file paperwork or pay any fees. While they're working, you can then pursue the H1B work visa, and it's after they get the H1B that you may want to consider pursuing a permanent resident green card. Next slide. And one of the things that we're going to talk about in connection with the H1B, whenever I talk to employers about any of this process, whether it's optional practical training or whether it's the H1B, the three main issues that employers care about when it comes to these to immigration matters is, what is it going to cost me to hire this individual? What fees and costs are involved in this? Secondly, what is the timing? Once I make a decision to hire this international student, when are they going to be able to join me? I mean, are they going to have to go home to their home country, and I don't know whether they're going to come back or when they're going to come back. So timing is an important issue as well. We're going to talk about that in connection with the H1B. The third requirement for most employers, or the third concern, is what are my obligations? What are my responsibilities to this international worker? And let me just allay that issue right now, because whether you're hiring somebody using optional practical training, or whether you're hiring an individual and then pursuing an H1B, your obligations and responsibilities to that worker are really no greater than they are to a U.S. worker. You can sponsor for the H1B, but that doesn't mean that they're an employee for life. You can terminate their employment at any time. When you sponsor for an H1B, it doesn't obligate you to that individual. If they run a red light, you're not responsible for their ticket. If you terminate their employment, you don't have to walk them to the airport. You terminate their employment, then it's up to them to have to depart the United States. So the obligations and responsibilities of an employer to an international worker are really no greater than they are to your U.S. workforce. And for many employers, that's good information to hear. Next slide. So this is the first stage, as I said, for an international student to stay and work in the United States, is to get this optional practical training work card. Crystal and I do these kinds of training sessions for international students all the time. We go through this slide in detail so that the international student knows exactly what they need to do in order to get themselves this optional practical training work card. You don't need this information. It is the student that is required to pursue that card, to make sure they have that card in their hand by the time they graduate. And as long as they have the card in their hand, they can go to work for you right away. Again, no fees on your part, no filing of paperwork with the government. That is all required for the individual student. Next slide. Now, as I said, every F1 student gets the 12 months of optional practical training. STEM grads, science, technology, engineering, or math, get an additional 24 months. But in order to take advantage of that additional 24-month STEM extension, the student must be working for an employer enrolled in the government's E-Verify system. If you have an international worker working for you using their optional practical training, and you like them, but you don't want to do an H1B, and you want to help them extend their optional practical training, if you're not enrolled in E-Verify, they cannot get the STEM extension. You don't have to be enrolled in E-Verify at the time the person goes to work for you. You can enroll at any time. So if you do have an international student working for you using their optional practical training, if you want to pursue the STEM extension, give me a call, send me an email, and I'm happy to answer your questions about the E-Verify program. But again, you have to be enrolled in E-Verify for that individual student to get the STEM extension of optional practical training. But I can tell you that when the student is working using their optional practical training, whether they have the 12-month OPT or whether they get the additional 24 months for a total of 36, everybody knows there's a clock ticking. And that clock is the end of the OPT time frame. And at the end of that time frame, the student will have a couple of options. They can either depart the United States, which most of them don't want to do, or they can pursue a longer term work visa. And that longer term work visa for about 95% of all international students in the United States is the H1B. And I'm going to turn it over to Crystal, who's going to walk you through the requirements for the H1B.
So the H1B visa is the part where the employer actually has to start putting some skin into the game. You actually have to start doing the sponsorship. You have to have a job offer. You have to sponsor the employer. If the employee, you have to make an actual filing with U.S. Citizenship and Immigration Services, and we're going to go into that in more depth. But I do want to explain why this is the most common work visa, and the reason for that is that the H1B is the work visa that is designed for college graduates. It's designed for specialty occupation and professional work. It's designed so that anybody from any country can have an H1B visa. It's not limited by where they were born or what passport they hold. It's a visa that any international student or any international employee can have. So at the point when you get to the H1B visa, you must have an employee who has a degree that's in a specific specialty. You must have a job that you want to offer them that requires that degree, meaning the job has to be a job that requires a bachelor's degree in a specific specialty. At this point, the employer has to be willing to do the same things that they would do for any employee. They have to pay what's called a prevailing wage, and the prevailing wage when it comes to the H1B program is the greater of the government statistics, what the government shows that that type of a job in that type of a specialty in your specific locality pays, or what you would pay any normal worker in your specific company in that same position with that same experience level. At this point, the employer is not required to advertise for the position or to prove that they can't find US workers. At this point, you're just proving that you want to hire this individual in a job that qualifies for H1B. So at this point, you as the employer would have to actually sponsor the employee. You'd be able to sponsor them for up to 6 years of work authorization using the H1B program. And it's split up into 2 3-year increments. So the first time that you're able to apply, you would get a 3-year H1B. And then in the 6 months before that first 3 years expires, you'd be able to file an extension of that H1B status. Now, the scope of H1B is you're doing the sponsorship, you're paying for the application, you're proving the job qualifies. They're going to receive work authorization only to work for you as the employer. They're going to receive an approval notice from the U.S. Citizenship and Immigration Services that designates who their employer is, what the dates of validity are, and it tells them that they're only allowed to work based on the conditions that you, as the employer, put into the H1B petition. Because in that petition, you're going to tell where the person is working, what job they're going to be doing, and how much money they're going to be paid, whether they're full-time or part-time. And you're going to be proving that they, as the employee, and the job itself qualifies for H1B. If they ever wanted to change employers, or let's say that you found an employee who already had H1B status and you wanted to hire them, you as the new employer would have to file a new petition for that employee. Because they already have an H1B in place, you would be able to do that under a provision that they call portability. You'd be allowed to file your own petition for that employee, that prospective employee who already has an H1B petition. You'd be able to file that as a change of employer petition, and under the portability provisions of the law, they could start working for you as soon as you filed a petition for that employee. So we're talking about H1B for 6 years, 3-year increments, and you as the employer get to assign where this person is going to work and what their conditions of employment are going to be. And they're only allowed to work for you while they have that H1B approval in place.
And one important note on that, and that is, as Crystal said, when you file an H1B petition, You tell the government, you describe the job the person is going to do, you describe the location, you describe the wage. If any of the conditions of the individual's employment ever change, you need to contact your immigration attorney to determine whether or not an amended H-1B petition may be required. May not be required, but if there are material changes in the terms or conditions of the H-1B employment, you may need to file an amended petition. So store that away in the back of your head.
All right. So other H-1B issues. So when you're sponsoring an H-1B employee, this is the point where you as the employer actually have to pay for everything that's associated with the H-1B. What you see on your screen are the different kinds of fees that are related to H-1B, and these are the new fees that are going into effect April 1st. So these are the fees that are going to be current. They expect this to be the fees for the foreseeable future. They would have to publish a whole new regulation before they could ever raise these again. This includes the attorney's fees. Go ahead, Mark.
No, I was just going to say that whenever I get a call or an email from an employer and they want to talk to me about OPT or they want to talk to me about the H-1B, about the first question they ask is, okay, well, what is this all going to cost me? And as Crystal said, the Immigration Service has just raised their filing fees. But the two categories of cost for H-1B really are the attorney fee. Most companies don't have in-house expertise, so they hire an outside attorney like me or Crystal, and the Immigration Service filing fees. So there's so much misinformation out there about what it costs to file an H-1B. Let me tell you that in our office, when we do H-1B, we charge $3,100, $3,100. Different attorneys charge different amounts, but that's what we charge. And then you have the Immigration Service filing fee, and you can see that there's a whole range of filing fees associated with the H-1B. But if you look at all of those various filing fees, what you're looking at between my fee and between these filing fees, a little bit over $6,000 if you're an employer with more than 25 employees. A little over $6,000 for an H-1B petition. So the misinformation that I hear all the time is that, an employer will call and they'll say, well, I heard it costs $15,000, $20,000 to do an H-1B. If that's the case, I'm either not charging enough or you're getting wrong information, because it is not nearly as expensive as many employers think.
And some of these fees do fall off for subsequent petitions. So when you file the very first petition for an employee, you're filing with the fraud prevention fee. The second time that you file for them, you're not filing with that fraud prevention fee. This training fee of $1,500, that falls off on the third petition that you file for someone. So these fees are the maximum that you're paying at the time. And every attorney is different. When you go to hire an attorney for these processes, you have to really investigate how much it is going to cost. What Mark quoted to you is it's called a flat fee. It covers the entire process. Some attorneys charge you on an hourly fee, and then you don't have that same certainty about how much it's going to cost. And so you just have to kind of explore with the attorney that you decide to hire how those fees are going to be calculated. All right. So here's the biggest issue with H-1Bs. The biggest issue is H-1B availability. We talked about a minute ago, new employees with H-1B versus H-1B holders who already have H-1B status. So if you're hiring somebody who's already had H-1B and has already been counted, they call it counted against the cap, then you're going to be able to file an H-1B petition for that employee porting their status. It's going to change their employer from whoever got them an H-1B in the past to you as the employer. If you have an employee who has never held H-1B status ever, then what you're going to have to worry about is the H-1B quota. Every single fiscal year, the U.S. Citizenship and Immigration Services, the U.S. government, starts their fiscal year on October 1st, and they open up a new quota of H-1B visa availability. They offer 85,000 H-1B visas. They separate those into two categories. U.S. advanced degree applicants, those are people who have graduated from U.S. universities with a master's degree or higher, and then all degrees. So what happens is those visa numbers become available, and everybody has to enter into a lottery system to try to grab those visas up. Our timing for this is a really good timing, as Marianne noted. The visas, actually, the lottery applications become available this year from the 6th to the 22nd. That's when all of this process that we're just getting ready to talk about starts. So what happens is we have those 85,000. Everybody enters, all of the employers who want to enter an employee into the H1B system for a current fiscal year will create an account on what's called myuscis.gov. They will enter each employee who would qualify for H1B status into that computer system. And then at the end, U.S. Citizenship and Immigration Services will take all of the entries. They'll figure out how many entries for each employee there are. They'll separate out those entries as one entry. And then they will separate out all of the people who hold U.S. master's degrees or higher. They select about 20,000 from that batch. The ones who are not selected from the U.S. master's degrees or higher get put back into all of the rest of the pile. And then they select another 65,000 entries to notify them that they're going to be eligible to file an H1B petition. So every year in the month of March, these applications for the October 1 new batch of H1Bs have to be put into entry. So once they've selected, on or about April the 1st, they notify all of the employers that their employee has been selected, and an H1B petition has to be filed within 90 days of that selection. So what we have on the screen is kind of a timeline. We've talked about students who come to you with 1 year of optional practical training available to them. We've talked about students who have 3 years of optional practical training available to them. We're going to look at this timeline as if the person has their optional practical training ending, right? Let's say that they were graduating in May, and so they ended up with optional practical training that runs from June to June. You hired them at the very beginning of their year. So you hired them last year in May, and they've been in June, and they've been working for you since then. Right now is the time to really be thinking about going ahead and entering those people into this H1B lottery, right? Because their current work authorization may be expiring in June, and they're going to need something. If you want to be able to keep having them work for you, they're going to need something to extend that work authorization beyond. So we have this March 6 to 22 period of time where you would actually enter for them, and then they would be selected in the lottery. So looking at our timeline, we're talking about right now they're only able to work until June. You're going to be entering them into that lottery system in March, and then you're going to need to file an H1B petition for them before that optional practical training expires. And if you do that, then what happens is the US government will extend their work authorization from that expiration date that they had coming in June to October when you wanted them to start working. We've talked about this lottery, right? We've talked about that there are 85,000 slots. Last year, there were 750,000 entries for those 85,000 slots. So you had a very low selection rate, where it was by no means guaranteed that an employee was going to be selected. What they've done this year is that they've changed the system a little bit, because what they found last year was that they were able to detect that the majority of applicants actually had more than one employer applying for them. So each employee might have 1, 2, 3, or even 4 employers that were filing a lottery entry for them. The way that they feel like they can make that more fair is that instead of this year just having that same employee be entered by 4 different employers and counting as 4 different entries, they consolidate all of the entries that are assigned to one employee for all employers who entered for them as one entry. They're hoping that that'll mean that the odds of selection are greater, because every person will be given only one entry instead of every person being given as many entries as they could get employers to sponsor them. So what they're hoping is that it'll be more like 1 in 300,000 instead of 1 in 750,000, or 1 in 250,000 instead of 1 in 750,000. The thought is that they're trying to make those odds a little bit better this year. Now, that means also that you can't guarantee that your employee is going to be selected the very first year that they are entered into the lottery. So if you have an employee who you know is going to have 3 years of STEM optional practical training, You might still want to enter them in the first year that they work for you if you know that they're an employee that you're going to want to keep long term. And even if you don't enter them in the first year, you might want to enter them in the second year. And so we have a lot of employers who end up entering their employees into this lottery system every single year that they work for them in optional practical training. So that can be done. You can enter them in multiple years. You're only allowed to enter them once per H1B lottery season. A single employer can only enter their own employee in one single time. So it's very, very, very important that we have to be very emphatic on that, because what happens is if they detect that a single employer has entered their employee more than once, they'll just throw out all of the entries for that employee. So very, very important that you make sure to be very careful to only enter each one of your employees one single time.
And let me just summarize really quickly. So on this little chart you see up here on the screen, so October 1 is when this quota is released, the 85,000 quota, the 20,000 for U.S. advanced degree, and then the 65,000. But to get one of those quota numbers, you as an employer get to pre-file to try to get one. And the pre-filing, the pre-registration period this year is March 6th through March 22. So we're just a couple of weeks away from the pre-filing period. If you have, let's look at two different scenarios under this this particular time frame here. So during the quota, the pre-registration period, March 6th through 22, if you have a student that you are interviewing and considering hiring, and they don't yet have a degree, can you go ahead and register them before they graduate? The answer is yes. So let's say you have a student who's graduating in May or June of 2024. They don't have the degree yet, but you can still file the pre-registration on their behalf anytime between March 6 and March 22. So you file the pre-registration. If the case is selected in the lottery, and as Crystal said, last year they received over 750 pre-registrations for the 85,000 quota, we'll be notified by April 1 whether the case is selected in the lottery. Once the case is selected, then you have 90 days to file the H1B petition. So you wait until the May or June graduation, which is within 90 days after April 1, and you file the H1B petition once they have the degree. As Crystal mentioned, they still have to be able to work in the United States between graduation and October 1, because October 1 is when the quota is released. The way that they continue to work through the summer up to October 1 is to use their optional practical training. Well, let's look at a different scenario, which is more common, and that is you don't have an employee that you want to sponsor before they graduate. You wait until after they graduate. They get their OPT, they start to work for you, they go to work, October 1 comes around, you don't care, you didn't file a registration form anyway. What you're going to be looking to do is to file the registration the following March, the March after their graduation. The pre-registration period for the H-1B quota is always in March. We don't always know the date until February, but it'll always be in March. You'll want to look at the March pre-registration period the following year. You filed your pre-registration. If the case is selected in the lottery, you'll be notified by April 1. Once you're notified on April 1, you can file the H-1B petition. And again, if it's approved, it will be effective as of October 1 the following year. So that's how the H-1B quota works. I can't say that it's great news, but we are all stuck with the quota, and it's very important to understand how this pre-registration process functions.
All right. So what we've been talking about is that H-1B lottery system. We've been talking about a system where if you're a for-profit employer, and most nonprofits actually, you're going to be subject to this cap lottery system where there's a limited number of visas available. This screen is for some of you who may be exempt from this, this cap in the number of H-1Bs available each year. The kinds of organizations that you see on your screen are exempt from this lottery. What does that mean? That means that employers who want to hire international students or want to hire international graduates for their positions don't have to worry about that lottery. They don't have to worry about the March limitations. They don't have to worry about any kind of numerical limitation. So universities, nonprofit organizations that are affiliated with universities, this could be research facilities, this could be hospitals that are affiliated with universities, this could be school systems that are affiliated with universities, nonprofit research organizations, and then governmental research organizations. And you'd be shocked at the number of employers who do not realize that they are exempt from this H1B cap. If you are a nonprofit entity, it's worth looking into your affiliation agreements. It's worth looking into your background to see if you're designated under one of these classifications, or could be based on the relationships that you hold with these nonprofit universities, to see if it's possible that you fit into this H1B cap exemption. Every single year we get a lot of different employers, different types of employers who weren't selected in the lottery and didn't even think of investigating this particular path. So if you are a nonprofit organization, it's really, really worth kind of thinking of this as one of the paths that you could take, because that could mean a whole new source of recruitment for you. So what this screen is all about alternatives, because we do have too many people entering in the lottery every year. Not every single employee or employer is going to get picked. So these are some of the other alternatives that you have as an employer to use for people who are not selected in the H1B lottery. A lot of students end up re-enrolling in school. Say that they had a bachelor's degree, they don't get selected in the H1B lottery, they might want to go do a specialty master's degree. So sometimes students with who go and enroll in a master's degree can get what's called curricular practical training, and then they can continue to work for you on a part-time basis, sometimes even full-time, depending on what the requirements are for their master's degree program, while they're in F1 status. That's one of the options that some employees and employers take if they're not selected in the lottery. Other options, if you have a Canadian or a Mexican employee, they have a different classification of visa called TN that they can use if they have a Canadian or a Mexican passport, and they are one of a multitude of different types of professional that are outlined in the regulation. If you have an employee who wants to take advantage of this, you can contact us and we'd be happy to go through and see if the type of employment you have would qualify. If you have an employee who is from Chile, Singapore, or Australia, they have their own variety of H1B equivalent. For Chile and Singapore, it's H1B1, for Australia, it's E3, that they can do. It has all of the same requirements, but a different quota that's never filled. People from those particular countries can qualify for those visas, and they never meet the cap for that so far. If you're an organization that is a multinational organization, you have related entities outside the US, it's possible that you might be able to qualify your employee for L1 status. This is really, really super fact specific. So if you think that this might work for you and your employee, you would definitely want to contact your immigration attorney and figure out if that'll work for you. There are some other options for extremely well qualified employees of really high talent level, meaning they're at the very tip top of their profession. Things like O1 that you see at the bottom of the screen, those also are things that you would want to have an immigration attorney look at. They use O1 for specialty physicians a lot of the time, for researchers, for all manner of different types of employment that are where it's just a very high achieving employee. All right.
You can skip to the contact information. I think as Crystal mentioned, there are some, that last screen that we showed that had the different alternatives to the H-1B. There are some available for treaty countries. There are some available for multinational companies. But in the end, most of those are very hyper-specific, and not many international students are going to qualify for any of those, which is why the H-1B is so important. And the H-1B quota is definitely very frustrating. It's frustrating for U.S. employers. It's frustrating for international students who are in the United States. But for the time being, we're stuck with it. We've had this quota for many, many years, and I don't see it going away anytime soon. With that information, what I want to do is turn it back over to Mary Ann, and we will field questions.
Mark and Crystal, and for those of you who have joined the call, before I founded GoinGlobal, I was, and I guess I continue to be, an employer. This information makes my head spin, and it spins even every time I listen to Mark and Crystal. So wonderful advice. I do have a two-part question, but I want to say I think the value of whatever law firm an employer works for, these regulations, having lived in Washington and worked for the government for 14 years, they are ever evolving. So the advice you heard today from Crystal and Mark, current, relevant, you better get right on it because it starts March 6th, but it is ever changing and ever evolving. So you can't count on the fact that the same thing you heard today is going to be the same rules and regulations come next fall. So this question is for either Crystal and Mark, and then it's a two-part question. I know there's a new regulation that you talked about briefly, and that was you cannot have the same individual. They'll be shut out of the process. This is where I get confused. We're taking an individual student. Are they no longer allowed to apply for a position through 10 companies, or are they no longer allowed to apply for 10 different positions within one company? And then I have a second part to that. That's a new rule and regulation, so that if multiple applications get submitted for one student, I want everyone on this call to hear, you are out of the program. So, or out of consideration or out of the lottery. So Mark and Crystal, can you clarify that a little further? Because that's new.
Go ahead, Crystal.
Yeah, so the rule is that each employer can only enter their employee in one single time. The government is really, really looking for fraud. They're really trying to make sure that they're trying to conduct a fair system. So they only want each employer to enter their employee once. They're also this year trying to make sure that each employee only counts once. So even if multiple employers enter them, they're going to be consolidating all of those entries into one entry using the name, date of birth, and passport number. So it's super important that you be very transparent. If you're an employee that's listening to this particular session, you're providing each of your employers with the same identifying information, same name, same date of birth, same passport number, because if it's detected later that, let's say, the employer entered under 2 different passports or the employee was entered under 2 different passports, that could result in a revocation later. So employers, you can only enter each employee once. Employees understand that the same information needs to be used on every single entry.
So, Crystal, what you're saying is students listening to this call, if they have 2 different passports, they cannot game the system and apply under 2 different passports, 2 different ID numbers, because if they get caught, they're thrown out.
Yeah, and the Immigration Service has been very good at ferreting this out. This is something that they are really putting a lot of effort into this year, and they've even made the statement in the regulation and in the comment that even if the H1B were approved and they later detected it, it could be revoked based on that fraud, and they would consider it fraud or misrepresentation.
Gaming the system won't work here. Crystal, you answered both of my questions, so I'll turn it over to you to choose a question from the chat.
All right. So in the chat, we see a question about that same thing. About when employers can file. So can employers file for the same employee in their first year working of OPT, or do they have to wait to the last March before their OPT expires? Important to note that you can apply for H1B, you can enter an employee into the lottery, whether they're an international student or not. They could be living in India, you want to hire them, you enter them into the lottery. They could be living pretty anywhere in the world. They don't have to have a US degree, none of that applies. So by extension, you don't have to wait until the last year of their OPT. You can apply for them in the first year of their OPT. You can apply for them before their OPT starts, as long as they're going to have a degree within 90 days of that lottery entry. You can apply for them when they've re-enrolled. You can apply for them when they're in another status. You can apply for them as long as they qualify for H1B or will within 90 days of the lottery. So if they're graduating in May and you know that they're going to start their OPT with you in June, you can enter them that year, and you can enter them in every subsequent year after if you want. Only once though. Okay. Second question that's on here is one that's close to my heart. Is asking questions about if there are any skipped steps for Ukrainian nationals. And what I think you're talking about is the fact that there are a lot of Ukrainian individuals who are here currently on Ukrainian humanitarian parole. They're eligible for a program called temporary protected status. Both of those give an employee independent work authorization, but it doesn't really give them a skipped step, right? It does give them unlimited work authorization. You can hire them and you can keep them during the validity of that employment authorization, which is awesome. And it gives them a way to come and do the same thing. You can still test them. You can still get to know them. You can still get to know that you want to sponsor them. But you still need to try to get them something that's going to last longer than that, because it's an uncertain program. As long as we have the current administration, they're going to probably continue giving Ukrainians these benefits. But if the administration changes, it's possible those benefits could subsequently disappear. And so what you want to be thinking of is, do I want to sponsor this employee for H1B, which is a statutory program that's going to be permanent? Do I want to sponsor this employee for a green card, which would be even more permanent? So yes, they'll have that work authorization. That's, I guess, kind of skipping steps. But you still need to be considering long-term what that employee is going to have, what options you want to have for that employee long-term in case that program disappears. There are some very, very specific questions. If the employer applied in the first year and the employee didn't get selected, then the application will be out of consideration for the rest of the OPT years? No, you can enter that employee every single year that you want to, but just once every single year. Pharmacy residencies are 1-year programs, but most programs actually are 12 months and a couple of weeks. Because it's longer than 12 months, will the OPT not work? This is a really, really super hyper specific question. So if I don't answer it completely, just email us. We do answer questions like these for universities and for students all the time, so we would be able to give more detail. Sometimes in this situation, you would be able to get an H1B to cover the rest. Sometimes you could qualify for a STEM OPT to get to the rest. Sometimes the school is going to give you what's called a J1 to finish the rest. It's going to be very, very school specific. It's going to be very, very situation specific. This also might be a situation where they're affiliated with a university, and so it's a cap exempt H1B. So there are just a lot of little moving parts here. It's very, very hyper specific. So definitely email us if you'd like more of an answer to that question.
So Crystal, with that, I am going to close the presentation. We're all, on behalf of everyone who's joined us for the call today, your advice, your counsel, your insights, so very much appreciated. As Crystal and Mark have repeatedly provided you with their contact information because of your affiliation with GoinGlobal, Crystal and Mark are available to give you complimentary advice. So please take advantage of that. I know a number of you usually contact us to want to have recordings of today's presentation. Those of you who are GoinGlobal customers, student and staff of the more than 800 universities GoinGlobal supports, you can find a link to this presentation. It'll be available by tomorrow morning up on the GoinGlobal platform. For the employers who have joined us today, if you will write to me directly at present@goinglobal.com, I will provide you with our compliments, a link to the full presentation as well, and also re-include the introduction information to Mark and Crystal. I do want to encourage the GoinGlobal customers on the call. We give our own training sessions about GoinGlobal several times a month, so you can learn more about our exclusive resources, jobs, further H-1B information, how to write a resume, interviewing that culture, everything you need to fast track your own job and internship search, whether it be here in the United States or elsewhere. Please join us for a training session also noted on the platform. It's with great honor that I'm able to tell you that Mark and Crystal will be joining us again. You can find the specific dates on the platform for a presentation in March, and another one in March, and another one in April. We are so lucky to have Mark and Crystal give us the benefit of their insights in advance. March 6th, right around the corner. So again, Mark and Crystal, on behalf of everyone, we have close to 500 people on the call today. What an honor it has been for all of us to hear about the ins and outs and the most recent changes in the rules of regulations for successfully gaining employment, taking advantage of that U.S.-based education and putting it in full force here to the benefit of all of us. So with that, Mark and Crystal, everyone who's joined us today, this is Marianne Thompson signing off for today's presentation, hoping you will join us again. Have a great day. Goodbye.